Thank you too. And thank you so very much for tuning in to the 2022 Law Week Lunch and Learn seminars delivered by Marrickville Legal Centre. Before I begin, I would like to acknowledge the Gadigal people of the Eora Nation, whose land I stand on today. I'd also like to acknowledge the custodians of the lands that you are zooming in from, and you're very welcome to write an acknowledgement in the comments if you'd like to do so. The lands that we stand on today hold structures of law that have been practiced for thousands of generations, and I pay my respects to the elders past, present and emerging. Now, my name is Codie Croasdale. I'm a solicitor at Marrickville Legal Centre, specialising in tenancy and civil law. Part of my job, a big part of my job, is equipping people, much like yourself, with the skills they require to be able to effectively resolve their disputes. It is really important to me that people do feel comfortable, as Tu was saying just a moment ago, approaching lawyers and aren't too befounded by the law. I know that it can be a really intimidating process, but I hope that this helps bring some clarity into, you know, some of the more confusing aspects of legal communication and other things. So with that in mind, today we'll be talking about how to effectively write and respond a letter of demand. There's many great reasons to learn these kind of skills or just continue to refine them. Not least because a great letter of demand can help you resolve your disputes without having to escalate litigation or other areas of the law. We want a quick, just resolution to any kind of dispute. A letter of demand can help you achieve that. Now, I hope this discussion provides some helpful tips, but the first, just a bit of admin. This session will be recorded, so you're welcome to turn your cameras off, put your microphones on mute, whatever you need to do to feel comfortable. Of course, it is, yeah, you're very welcome to also ask questions throughout the presentation. I'll be taking questions periodically, and as I mentioned earlier, you can just put your hand up as well. Now, the information provided today is exactly that. It is information. I hope it's really helpful to you, but please don't take this as legal advice. That's what contacting your local community legal centre for specialised, personalised advice is for. This is going to be very general. It's going to cover a lot of general subject matters, and I'll mostly be focusing on legal skills rather than the law itself. And if I do refer to the law itself, I'm most likely referring to the law of New South Wales, which is where I work. But of course, these kind of skills might be applicable to other states, territories, even countries. I'm not too sure. I won't get too carried away. But this is, as I said, a very general kind of principles. Now, to get free legal advice, if you are in New South Wales, try your local community legal centre. If you're not sure how to find your local community legal centre, you can try the CLC directory on the CLC New South Wales website or Community Legal Centre's Australia website as well. All right. Now, all that aside, let's talk about letters of demand. Why a letter of demand and what is it? So a letter of demand is a letter addressed to a party that demands an action within a specified time frame. Letter of demand will usually indicate something's owed by the other party and demands that whatever is owed be returned to the person that's writing the letter. For the purposes of our chat today, we will be talking about letters of demand that are for goods and money. There are other kinds of letters one can write as well, but for the sake of simplifying what is otherwise quite a complicated topic, we're going to be focusing on goods, money, mostly money. So why should you send a letter of demand? So you're in a dispute. Perhaps someone's crashed into your car. Maybe you've overpaid your rent. Maybe you've left your belongings at a storage facility. Or maybe the company that you've provided them to won't give them back. Maybe you've loaned someone money and they've defaulted on payments and you haven't heard a word from them since. Or it could be that you've had a faulty product and the company won't give you a refund. Now, a letter of demand can be sent in countless different circumstances. Those are just a few examples. But in any case, I guess the unifying factor is that something's gone wrong somewhere and you want to try and fix it. A letter of demand is a really helpful first step in trying to resolve those disputes where other friendly mechanisms or things like phone calls or messages, your usual friendly dispute resolution means have failed. Try a letter of demand as the next step. It's a bit more serious. It sets out essentially what you're asking. It tells you what will the other party what will happen if they don't comply. And the aim of any kind of letter of demand is to essentially resolve the dispute. We don't want to escalate to court. Going to court is expensive, it's time consuming, it's complicated, and a well-written letter of demand can help avoid that issue altogether. So a respectful but assertive letter can be a very powerful tool. All right. So first steps. I'll get into the nitty gritty of writing a letter of demand in a moment. For the time being, I want to just take a moment to appreciate some of the first things that you should probably consider doing before you even get to that step. The first of that would be, of course, identifying the other party, identifying what you want and why it should be given to you. Have you tried other means of getting it? For example, like I said, approaching the other party and asking for a refund before sending a letter. And have you had legal advice? You're going to hear me say that a lot, and I do apologise, but I don't apologise as well because it is really important. It is so important that you know whether or not you have a leg to stand on, legally speaking, and find that out before sending some kind of letter. But I'll talk about that a bit more later. You'll keep hearing me saying it. For now, I just want to talk about that first step, and that is identifying the other party. Now, goes without saying, anyone can send a letter of demand. Who you send it to is what we're talking about next. Anyone, if someone owes you money or owes you goods, you can send them a letter. You can also send a company a letter. If you are sending a letter to a company, try to identify the details of a manager or the appropriate team that does handle complaints. That might help you get your letter to someone who's going to treat it seriously rather than a frontline employee who may just put it in a drawer and leave it alone. Now, just a note here, the manager, if you do address the letter to a manager, if you do address the letter to a specific person, or maybe you have an issue with that a person from that company, they may not be the other party. In fact, it's unlikely that they are. It does depend on a case-by-case basis, but generally if a company has done you wrong or an employee of a company has done you wrong, it may well be the company themselves that are liable. There are variations, of course, but I just wanted to make that really clear. First of all, that employees are often representatives of the companies that they work for. And if you have an issue, for example, with a good that you purchased, the other party is the company. Okay, so the company is who you're going to be writing your letter to and trying to resolve the dispute with. Now, it's really important that you have the correct details of anyone you write a letter to. It sounds a bit obvious, but it's also can be surprisingly complicated sometimes. I suggest making sure you have either an email, a postal address, just as a preliminary, so you can send a letter to the other party. Now, if you're having trouble identifying these details, and it does happen, my biggest tip is just to use the resources that are currently available to you. Try Google. Have you asked any friends? Could you have a look on the company's website? What means do you currently have before, trying any further? It is really, really difficult to pursue money from someone if you don't have these preliminary details. And you're better off trying to get those details now rather than later when you've already applied to court or tribunal. So, second step, what do you want and why? It's really important that you try and work out what you want. I know if you've reached this point, you probably already know what you want, but I would encourage you to think a bit deeper on this. Identify your boundaries, identify what you're comfortable with, and why the other party should give it to you. Now, I've said it before, I keep saying it. Try to get legal advice before sending a letter. This will help you determine whether you do have a cause in action. It's not always straightforward when someone owes you money. And expert advice from a third party who knows the situation and knows the law and can help you identify whether or not there is a legal basis for your claims will help you be better equipped in the long run. You want to know if there's a legal basis and not just start sending letters willy-nilly, because if you bring a matter to court, you could be held liable for any costs arising from unestablished claims. So an example of where this may not be as straightforward as one would expect would be motor vehicle accidents. Sometimes it's unclear who's at fault. Sometimes both parties can be at fault. And in those kind of circumstances, costs may be split between the parties or portioned between the parties, depending. Now, knowing where you stand can not only help you compromise, negotiate, work into some kind of solution, but it will also help you reach a swift settlement. And when it comes down to it, unless you've got months and months to spare and you're looking for a fight, you generally want to try and resolve that as quickly as possible. Now, which brings me to compromise, I guess. No one really likes to hear the term compromise when it comes to a matter that's close to their hearts. I know that sometimes it feels like it's the principle of the matter, but sometimes it can be in your interest, like I've just mentioned, to negotiate or accept a reduced amount. Think about your priorities. What is the main thing that you want out of this situation? Is there something that you'd be willing to negotiate on? Is there a lesser amount you'd be willing to accept? Are you willing to accept payment plans? Or alternatively, are you willing to put time and money into fighting it all the way? It means essentially exploring these questions and just knowing your boundaries, knowing before you write the letter means that you can approach the letter strategically. You can approach any potential negotiations strategically. And it will also give you the opportunity to look for common ground between you and the other party, so you have something to work with. And I'll be talking about negotiation a bit further into this presentation, but I wanted to just flag this now because I do think it's really, really important. Another thing I might just mention quickly now, when it comes down to working out where you stand, what you're comfortable with, sometimes it's good to think ahead. Like if the other party, who you're pursuing money from, is in financial hardship, it's possible a court would order a repayment plan anyway. So if you go to court because you don't want to accept a repayment plan now, the court may nevertheless order one later anyway. So it can save you a lot of time and hassle just to, make that offer from the forefront. Be reasonable. Think about, again, what you want. Now, I'm going to talk about the nitty-gritty of what we're put on a letter of demand in just a moment. This is going to be the more practical, where do you put what, and yeah, the exact kind of basics of writing a letter of demand. But for now, I might just ask, does anyone have any questions about anything that I've just mentioned?
Feel free to unmute yourself and ask away.
I'll continue for now, but do please let me know if there are any questions or concerns you might have. I'll move on to the next slide, which we're talking about the basics. Now, a letter of demand will set out what is owed and why. It'll also tell the other party what will happen if they don't respond. In writing your letter of demand, cover the basics. I've listed a few here on the slide, but in short, I guess you want to show your details, the other party's details, the date the letter was sent, an explanation of how you sent the letter, an outline of what you want, for example, the goods or money owed, an explanation of what has happened and why the thing is owed. Now, I'm going to unpack that a bit more in a bit because it's really important to identify the real issues in that particular section. We want to show why the other party is liable and why you're not. Walk them through the argument in a really clear manner, and we'll talk about that in just a bit, but just to flag that now. We'll also potentially add attachments, for example, proof of why the money is owed. Be strategic about what you attach to a letter of demand. You don't want to give all give the other party too many documents, overwhelm them, and a lot of them aren't relevant. But if there are things that are, go to the heart of the fact in issue, like a repayment plan that wasn't complied with, absolutely attach that. Remind them of what the obligation was, what the agreement was, or, something like a receipt, an invoice for a motor vehicle accident claim. Include attachments that are relevant to your claim. It's really important and can be very helpful. It saves going back and forwards with more letters later. You'd also want to include a method of repayment. Often I'll actually just put a bank account details down, put your BSB, your account number, set a date when you expect repayment by, an indication if you are willing to pay by installments. I'd write that in the letter. And if you're willing to negotiate, it can be helpful to mention that too. You're totally going to get the vibe from me that I'm all about negotiation. And it's true. I think that it's so important to try and meet people in the middle. Obviously not in all circumstances. Sometimes there are circumstances where, you're owed the full amount and it's just not feasible or practical to negotiate, or the other party isn't coming to the table. But I do think it's really important to indicate that you're willing to negotiate if you are. And finally, an indication of what you're going to do next if the other party doesn't respond. That could include going to the court, going to the tribunal, making a complaint to the relevant body, and so on. So, framing your argument. This is the bulk of the letter, okay? And I'm going to, don't worry, I am going to show you some letters, so you're not just hearing all these words. I know it can be quite hard to conceptualize when you are just, hearing someone speak about things. So I do want to go through a letter with you in just a moment. But for now, just a few points. When in the body of your letter, you're going to be talking about your argument, why the other person owes you money or owes you goods. You want to try and keep this as concise and as clear as possible. It's nothing worse than a giant block of text that's hard to understand. You want the other party to very clearly be able to identify the facts, any relevant actions. And I think there's this real inclination here for people to use things like excessive legalese or complicated words, things like henceforth and I hereby announce that you must pay me the sum of XYZ by, you know, all of that, as far as I'm concerned, is unnecessary and complicated. I really do think that there's a beautiful thing about clarity. You want people to understand what you're trying to communicate with them. And if you don't, it's not going to be an effective letter. You might still get an outcome, but when it comes down to it, if you're going to write a letter, you want to try and put your best foot forward here and be polite, make sure the other party is on board with what you're saying. And I guess another way of trying to make it clear is actually making sure that any facts you present the other party are listed in a chronological manner. That means providing dates and then providing what happened after that, again with the relevant date, with the relevant mode of communication, if it was a communication between two parties, for example, an email. You want to try and set out what happened as quickly as, sorry, not as quickly as possible, as clearly as possible. And dot points, if you are finding that you've got a big wall of text, dot points can be very useful here. Another thing I like to mention is white space. It's really nice to see white space. I feel like it can make things much easier to look at, easy on the eyes. You want your letter to be easy on the eyes because you want the person to be able to, read your letter from the beginning to the end and not just think, oh, this is too hard, throw it in the bin, Yeah. We don't want the meaning to get lost here, and we want your letter to be taken seriously. Which brings me to the next point, which is, be polite, use persuasive language to help show the other party why you're reasonable and why your argument's reasonable. Now, that's enough. Without having examples in front of you. I'm going to actually just move to a few letters just so you can see what I'm talking about in real terms. So, all right. So here we have a letter of demand for outstanding money. In this circumstance, our friend, maybe it's you, lent someone a sum of money, $1,000, but unfortunately they haven't had it paid back. Now, I would note a few things about this letter. First of all, it is a bit matter of fact. It's very polite, but there's not too much gloss on it. If this is someone that you're friends with, if it's someone that you've had some kind of friendly relationship with in the past, you might want to add a bit of nicety in there. Things like thanking them for reading the letter, that kind of a thing. But this is just kind of matter of fact. It sets out the basic principles that I'm talking about. Now, you'll find in this circumstance, you've got your name, you've got your contact details. Very important. We've got the date that the letter was sent and how it was sent. We've got the other party's name and contact details. And then we've told them from the get-go, we've provided a little heading to let them know exactly what the letter's about. And if that wasn't clear enough, the first line gives it all away. So we're saying, I'm writing about the money you owe me. $1,000 was due to be repaid to me on date and remains outstanding. So we've been direct. We've been upfront about what we want. And I think that's really important to show from the get-go exactly what's happened to lead you to this point. Now, below this opening line, we've got a bit of a background. It's important to provide a background just for the sake of showing and establishing why the money is owed. So on insert date, you asked me for a loan. In an email, you said that if I lent you $1,000, you would return the money to me by date. I agreed to the proposed terms and paid you back by bank transfer on the same day. Please find enclosed a copy of the written agreement and bank transfer receipt. So this is a summary of exactly why the money is owed, and essentially specifying any relevant dates, how how the agreement was made, and we've also actually attached the agreement to the letter. I think that's really important here because we do want to prove that you have evidence that this was a loan. This wasn't just a gift. This wasn't just money provided just because you're a nice person. There was an agreement, and the other parties rescinded on that. Now, we've listed that there is a request for contacting that you had attempted to contact the other party in the past to request repayment. That's always good to mention as well as possibly one of the more important parts, which is a summary of your argument. That background that I've just mentioned summarizes that this was a loan. And now you're telling the other party, because the money was provided to you as a loan, you are not entitled to keep the money. That's, in essence, your legal argument there, okay? Next, we're asking, or rather telling them, what to do next, and telling them what will happen if they don't come to the table and compromise, okay? Or rather, pay you the amount in full. So we've asked them, repay $1,000 in full within 14 days of the date of the letter. Repayments should be made by electronic transfer to my bank account, which I've listed below. Again, you can see included the name, the BSB, and the account number. And we've also offered to talk about a repayment plan in case the other party can't pay. I've talked about it before. It's always good just to mention that if that is something you're open to. But of course, if it's not something you're open to, I'd rather you not include it. Don't make promises you won't keep. You want to be seen as the reasonable person and the reliable person. So finally, and to summarize, at the end of this, we've let the other party know exactly what will happen if you don't hear from them or if you don't get payment. And that is, in this circumstance, that you reserve the right to go to the local court to recover the money. Okay, so that's a basic summary. We're going to move to another one next, and this is a bit more complicated. And sorry, it looks like there's a bit pixelated, but I hope you can read that okay. I'll read some of it out as well, and look, you'll see that it follows a very similar format. It's just a bit different because it's a slightly different subject matter, but I guess, yeah, bearing in mind the same principles apply. In our first line, we've told the other party what we're there for. We're asking them, or we're telling them why we're writing the letter. I'm writing to you about the motor vehicle accident that occurred at address on date. That is really important. You want to be clear about, when and where the accident happened, and who are you? I am the owner of the car with registration number, include your registration number, which was damaged because of the collision with your car. If you have their registration number, include that. Okay. I was parked on the side of the road when your car ran into mine. You were driving at the time. My car was stationary and in an allocated parking spot when the accident happened. And something I like to mention just briefly is that I really like short sentences. I find that short sentences are a really good way of conveying exactly what you want in a punchy manner, right? You want to show, first of all, my car was parked, you were driving, my car was also in a allocated parking spot. Next line, The accident was caused by your negligence, so you were responsible. Okay, so we've provided the background, and now we're telling the other party why they're responsible for this amount of money. Now, I mentioned in the last letter, always good to include attachments. This is especially important for any kind of motor vehicle claim. You're going to want to go to a panel beater, go to a mechanic, go to whoever you need to go to get a few quotes, work out exactly how much is owed to you, and then you can provide it as an attachment on the letter. So I do suggest, wherever possible, specifying exactly what was damaged and the cost, and then providing that as an attachment. Again, the rest of the letter kind of remains in the same format. I ask that you repay me this amount within 14 days, payments to be made by electronic transfer. There's my account details. Let me know if you need a repayment plan. And if I don't receive payment, I will consider going to the local court. Okay, again, similar format, slightly different. And I've got another example to show you. So moving on to the next one, consumer complaint. A little bit different, but again, quite similar. This one talks about consumer guarantees as the basis for the claim, and provides, talks about Australian consumer law. But generally, when making some kind of consumer complaint, the structure kind of talks about the same. You want to identify the basics. First of all, what is your complaint about? Is it a product? Is it a service? Tell the other party what you bought, where you bought it from, and on what date. That's your basics, so include that in the first line. Next, the background. When I purchased the product, I was told that it would be in new condition and in working order. Unfortunately, the product you sold me was visibly used and I've not been able to turn it on. I followed the steps outlined in the product manual, but the product still doesn't work. That's your background. And I think the main things to take note there is that you've told, first of all, what the issue is. You were told one thing and you were delivered something different. And you've also showed, you'll note, I followed the steps outlined in my product manual. I've included that to show the other party that you have tried to resolve this yourself. You have called IT, so to speak, or consulted the manual, or maybe you've even looked up how to turn the thing on. Maybe you've charged the phone or the computer before trying to use it per the instructions. Whatever it is, you want to tell the other party why this is not your fault. This is not something you're liable for, or that you're not a silly, you haven't made a silly mistake or anything with it. Like, this is actually a them problem. So yeah, helps establish their liability essentially. Now, again, we've included attachments. In this circumstance, a photograph of the product showing that it's in poor condition. I've also attached a proof of purchase. That could be a receipt. It's always good to just establish that something was purchased and you're not just asking for a refund for something a bit random. And yeah, next, we're just talking about the consumer guarantees. I'm not going to talk about these too much in this presentation. That's not part of the scope of what writing a letter of demand, the kind of practical skills of writing a letter of demand is about. So it's a bit beyond that, but there are some really helpful resources you can use. I've got a bunch of links towards the end of this presentation on the slide, but I guess the main thing I would say for now is ACCC website do have some really great fact sheets and information on consumer guarantees. They're excellent self-help resources. I'd also suggest having a look at the Office of Fair Trading website, assuming you're in New South Wales, because yeah, that should provide some background on consumer guarantees generally as well. And I guess the main thing is you just want to establish if there is a claim there. You can talk about why. You can talk about the fact that there are certain guarantees that are afforded to consumers. The product should have matched the description, and it should have been in working order as advertised. You can talk about the self-help remedies that you've tried already. You've tried to approach the salesperson. You've asked them for a refund, but it was refused. And so because of that, you've escalated the matter through this letter, and you would like the other party to let you know what they think or arrange a refund within 14 days. Again, at the end of the letter, we've talked about what will happen if the other party doesn't come to the table. And in this circumstance, I've said that we'll consider lodging a complaint to Fair Trading. Okay. I've also included a thank you, because it can be nice to thank someone, especially if your decision is being considered by someone different compared to who made the original decision. So, all right, moving on. You've got your great little letter of demand. You're ready to send it. What's next? How do you do it? I guess you can just send it by post, fax, email. You can also physically hand it to a person. Just remember to include it on the letter, preferably how it was served. For example, by post and the email address, or if by email, the email address to which you sent it to. Keep a record of these things. It can be really important, especially if you are going to take further action. And a bit of a side note as well, one thing I do recommend is if you are sending a letter of demand by email, don't copy heaps of different people in. The main, I guess, point is to identify that other party through the mechanisms we discussed earlier. Find out who that other party is and send it to that person. Or the best representative for that person, if for a company, if the other party is a company. So you basically want your claim to be taken seriously. You want it to be sent to the right person. And if you copy a wide range of different people into your email, unfortunately, it does sometimes discredit the claim a little bit. For example, let's say you copy NCAT, that's New South Wales Civil and Administrative Tribunal, into your email. If you do that, you're essentially taking the power out of your hands on how they might respond. For example, they could reply all to your email and say, please don't copy me into your emails. Not a great look. You want to avoid that as much as possible. Because when it comes down to it, this letter is just to the other party. You can keep a record of having sent that letter if you need to refer to that later. But yeah, just send it to them. Maybe if it's a company, you can send it to a few different people within that company, but be targeted in your approach. So you're treated seriously, as seriously as possible. Okay. What happens once you send the letter? Few different things that can happen. I'm going to be quite brief about this right now because we're about to move on to the second part of the topic, and I appreciate that we are it's going quite over, so I will try to speed up a bit, but I guess first things you can do is essentially wait for the due date. Make sure that you've given the other party an opportunity to respond before then, and don't just jump straight into action. The other party's response will be up to them. You can't really control that, unfortunately. They may choose to deny, admit. They could ask for more information, and if they do, you should provide them with that information insofar as it is appropriate. They might try to negotiate, mediate. I encourage you to come to the table then. If you do not get a response, and that is possible, Consider getting legal advice. Determine the next steps. These next steps will largely depend on the nature of your inquiry and might include going to a community justice centre, complaining to fair trading, applying to the local court or NCAT, or maybe it's something else entirely. Bit beyond the scope of what I'm talking about today, but I guess for now, I'm just going to move on to responding to that letter. So what happens if you receive a letter of demand? First thing I want to note is that you should be taking it very carefully. You should be reading it very carefully. Check for any deadlines. Remember that 14-day deadline that I suggested people use before, and note that the other party may commence action to recover the money. Now, I guess know where you stand as well. Have a think about how do you owe the other person money? Be realistic about it. Think about whether you agree to the full amount, whether you agree to part of the amount, or maybe you just don't agree at all. Look and think about the evidence that both parties might have and approach it from there. I've kind of just went through this a moment ago, but you can acknowledge and pay the amount. You can deny the claims. You can ask for more information. You can negotiate. You can mediate, or you can do nothing. And again, I don't necessarily suggest you do nothing at this point. One thing I would say is that if you do disagree with what's on the letter, I strongly encourage get some legal advice. Just get that third party opinion again, and do consider especially getting legal advice if you are in any kind of hardship. Now, make sure you have a record of any payment. I'll talk about in just a moment what to do if you reach a settlement, but I do recommend settlement agreements wherever possible. And if you disagree, know that the other party may pursue legal action against you, and depending on the finding, costs can be added to that. If you're in hardship, do seek legal advice, seek financial advice, try a local community legal centre. And I'm not going to go into it too much other than there is support available, and we want to speak with you. If you are having a really hard time at the moment, let us know. All of this advice, all of this information today is very general, but there are potentially other avenues that you can pursue. So please give us a ring, give Lifeline a ring too, because they're fantastic, or the National Debt Helpline for some financial counsellors. If you need more information, you can ask the other party for further and better particulars. Here's a sample letter of something you might be able to say. Basically, you're asking them for more information about how they've substantiated their claims, or asking them exactly what they're talking about. Maybe it's not the best or the most well-written letter of demand. So this sample letter gives you an idea of something you can say in reply if you just need more information, and goes without saying, but take action within the deadlines on the letter. All right. So negotiation and mediation. If you receive a letter and disagree with the amount asked, you can ask for to negotiate for an alternative amount of money with the other party. If you are negotiating in writing, make sure you write without prejudice on any offer. Any time you write, for example, I can give you XYZ amount, write without prejudice, because that means it won't be able to be used against you in court if the matter does escalate despite your best efforts. Now, initiating proceedings is a big deal. It can take a lot of time, effort, money, and it provides unnecessary stress that you probably don't want to deal with. So I really think the power of negotiation is absolutely brilliant here. You want to try and reach the outcome you desire without on your own terms rather than involving a magistrate or a tribunal member to make that decision. Think about the limits on how much you're willing to accept. Think about how much is being claimed, what's the amount of money you're happy to accept or pay. If you owe money, were you able to feasibly pay? Do your calculations, work out your boundaries, and go into any kind of negotiation with that in mind. I really do think that knowing where you stand is a important step, and opens up those doorways on what is and isn't a reasonable offer. Think about what the other party wants as well and why it's in their interest to settle. If you're considering their interests, you can be a bit more strategic in what you're offering them. And I'm going to go into that in just a moment, but before I do, I just want to flag that if you're having trouble with mediation, I do strongly suggest a community justice centre, not a community legal centre, a little bit different. They help you with free mediation. So yeah, I certainly recommend that. So I'm just going to flip over this next letter. This is just a basic letter in which you're saying that you don't agree with the full amount claimed. You're providing reasons. Have a little look at your own time. You should hopefully get a copy of the slides after this. But this letter, I've provided some of those basic principles. We've offered an alternative amount of money. We've told the other party that the person writing the letter, wants to resolve the matter with you, but I can't afford the amount that you're asking from me. I'm a single mum of 2 on a very low income, and you can talk about your circumstances a bit more or adjust it to your own circumstances. This isn't necessarily relevant to the fact and issue, but we want the other party to understand where you're coming from and why you're trying to reach this settlement. You're providing an offer. I'm willing to accept, or rather, I'm willing to pay you XYZ as a lump sum payment in full and final settlement. While I appreciate that this is not the amount that you asked for, I'm able to borrow this amount from a friend as a once-off. They're able to they're unable to offer me any further financial assistance, and I do not have any other support. So basically what we're saying is we can pay you a lump sum payment now, or in the alternative, you're going to have to pay it by installment. So you can accept a lesser amount if that's in your interest to do so, or you can have the full amount maybe, but it's going to take a really long time to get it to you. Think about what the other party wants, move strategically in that respect. Now, moving on quickly because I am taking quite some time and we're almost there, we're almost at the end. The main things that I just want to note is that if you do reach an agreement, get it in writing, be really clear in your wording, be unambiguous, set out any relevant dates, how much is owed if it is about money, or any actions, repayments, and also describe what will happen if the other party doesn't act. Next thing you probably want to note is that it's in full and final settlement. That's really important to make sure this is the final claim in the matter, and then no other claims can arise from that. And make sure everyone's signed it, everyone's on board. I won't go into it too much more. I do suggest getting legal advice if you are reaching a settlement, just to make sure that you've covered all your bases. Red flags. Watch out for, obviously, if you get a letter of demand, or if you receive an application to the New South Wales Civil and Administrative Tribunal, that to me is also a red flag. It means the other party has escalated the matter. You're going to want to watch out for a notice of hearing or notice of directions. A statement of claim also is an indicator that the other party has taken action. You should get advice as soon as possible after receiving a statement of claim. You normally will have 28 days to act. Moving on, here are some helpful resources that will hopefully help you and assist you with drafting an effective letter. Our website, Marrickville Legal Centre, does have an amazing little chat bot called Nala. You can plug in, have a little chat to Nala, plug in your inquiry, and should be able to generate some information and correspondence for you. Otherwise, Law Access is a great resource. Financial Rights Centre has some really helpful tips. The ACCC Consumer Complaint Tool and the Tenants Union website are great if your complaint is about those kind of matters. National Debt Helpline and Lifeline if you need financial counselling or just counselling, because it's good to talk to people sometimes. Now, that's a lot of information. Thank you so much for listening. And does anyone have any questions?
There is a question from Tommy in the chat. Tommy, would you like to unmute and ask your question?
Okay, I have 2 questions. So when sometimes water bills or whatever the bills comes in and I forgot to pay, then they give us a reminders of a payment. All those things also counted as a letter of demand in legally?
You know what? That's a really good question. And it kind of depends, because letter of demand is a very broad term. So lots of things can be a letter of demand. Essentially, they're asking you for money, but usually I wouldn't necessarily. I mean, it does fit all the principles of a letter of demand, to be honest. It's got a required action. It tells you why the amount is owed, and it tells you when you need to do it, pay it by, and it also says what will happen if you don't comply. So yes, you could say that's a letter of demand, but generally it's not the letter of demand that I guess I'm talking about today necessarily, but it is a letter making demands. Often what you'll find is if you are getting those outstanding bills, if you have your debt referred to a debt collector or another party who's trying to pursue that off you, chances are you're going to get a letter of demand that kind of fits the format that I've been talking about today. But yes, you could certainly argue that they are letters of demand. They're just a bit different. It kind of depends on the letter itself.
I'm sorry, just quickly then, if I issue the letter of demand to other person, do I have to give them a kind of reminder period, like 3 times if they are not replying?
Oh, that's an excellent question. So I think it's important to note like the distinction between a bill and a letter of demand. So if someone's invoicing you for something, again, it's hard to say without actually seeing examples, but if a utility company is invoicing you something, I would say that's distinct from a bill. Now, if you send her a letter of demand, you don't need to send follow-ups. You've provided a deadline for the other party to act, and you've also told them what will happen if they don't act. So as long as you've got that deadline on there, you are able to escalate the matter if that is something that you've decided to do after that 14-day period. So you don't need to send reminders unless you think it's going to be in your interest to do so. But usually I would say once you've sent the letter, put it in the post or send it by email and then just wait. Wait a little while, see how the other party responds, because you don't want to bombard them with information either. It's a bit of a tricky balance, but once you've sent the letter, I just leave the ball in their court for that 14-day or whatever that deadline you've provided, and you don't necessarily need to send any reminders.
Okay. Thank you.
You're very welcome. It's a really good question. Does anyone else have anything though? Any burning questions or?
Yeah, Codie. Hi, it's Joe.
Hello.
Hi, just a really quick question. It's probably more into the process rather than anything else. So assuming that the end process will be not NCAT or local court, but not NCAT, but local court application.
Okay.
A letter of demand was, and we send a letter of demand. and then they come back, I don't want to pay or whatever it is. The next letter obviously will be, and this is the question, this is where the question comes in. Do you then write to them and you would attach a draft statement of claim, or do you provide a statement of claim already lodged and stamped, and then, yeah?
That is an excellent question. I actually think that if they come back to you and say that they're not going to pay the amount, I think that that's an excellent opportunity to, again, push back, say, do exactly what you've just mentioned. You can, if it is a matter going to the local court, attach, I would probably, personally, I would be attaching a draft letter of demand and saying that I will be filing this on this date if you don't respond, and then press that you want to try to negotiate, you want to try to reach an outcome with them that's outside of tribunal, but this is ready to go. This letter of demand has, rather, this statement of claim is ready to file at the local court, and that way you've kind of put them on notice. I'd probably take that personally, and it kind of is a matter of everyone's got slightly different processes, but I'd probably keep it at a draft format rather than going straight to the local court and then attaching the statement of claim. You'd need to serve the statement of claim on them anyway, but at least then you're actually reaching out to them before filing and before having to pay a filing fee as well. So, it's just it's another step in a process, but usually you'll have 6 years to recover a debt. So, if an extra letter can save you going to court, then yeah, I'd go for it.
Thank you.
Thank you.